Ladies and gentlemen, welcome to our Town Hall Tuesday debate about the latest challenges to the Affordable Care Act. I am Jeffrey Rosen, the President and CEO of the National Constitution Center. And I am thrilled to be looking out over a hardy band of lovers of constitutional debate who have braved the blizzard to turn out to hear the best arguments on both sides of among the most important constitutional issues in the country. Ladies and gentlemen, this is why I love this job and I feel that I'm in constitutional heaven. We had a month ago another debate about an important constitutional issue, namely the religious liberty rights of corporations. And once again, it was an incredible snowstorm. And once again, several of you, I see some repeat players who've come to listen to this wonderful debate. I hereby award you honorary Alpine membership in the National Constitution Center's hardiest group of visiting scholars. So much appreciate your dedication to this debate. And you couldn't have two better people to explain the issues to you. They too have braved the storm. Professor Adler has taken the last plane into Philadelphia. Lazarus has taken the train from Washington. And these are among the most thoughtful commentators, as well as most influential commentators, on both sides of these complicated questions involving three challenges to the Affordable Care Act. And they are going to help us understand the issues together and cast some light on them. So let me briefly introduce my very well-known colleagues. Jonathan Adler is the Johann Verhey Memorial Professor of Law and Director of the Center for Business Law and Regulation at the Case Western Reserve University School of Law. He's a senior fellow at the Property and Environment Research Center in Bozeman, Montana. He contributes often to the National Review Online and to the popular and illuminating legal blog, The Volokh Conspiracy. And he's a commentator on many prominent radio and television programs. Lazarus is the senior counsel to the Constitutional Accountability Center. Before joining the center, he was public policy counsel to the National Senior Citizens Law Center. He's also served as associate director of President Jimmy Carter's White House domestic policy staff and a very frequent commentator in many publications. I have to confess, too, these are both old friends. Cy and I are colleagues from Washington for many, many years. And Professor Adler was a former student as an undergraduate in an undergraduate constitutional law class. And he was the star student in the class and basically the best student that I ever saw while I was teaching undergraduates. So I'm not surprised that he's back here today. All right, let's jump right in. So we have three cases to talk about, and they're complicated. So we've got to go through them closely, and I want to make sure that I've got them right. There are three pending legal challenges to the Affordable Care Act that we're going to talk about. The first involves arguments where states say that the plain text of the Affordable Care Act doesn't give the Internal Revenue Service the authority to give tax credits to those who buy insurance on the federal exchange. The second claim is that the president's decision to delay the implementation of parts of the Affordable Care Act violated his constitutional duty to take care that the laws are faithfully executed. And the third claim is that the individual mandate, which the Supreme Court upheld last year as a legitimate exercise of Congress's taxing power, failed to satisfy the requirements of the origination clause of the Constitution, which provides that all bills for raising revenue shall originate in the House. These are technical even for legal scholars. You know what, just to set the stage, let me ask a question of both of our panelists. Do these seem like unusually technical challenges? Why are they so hard to explain in ordinary English?
Well, I think part of the reason they're hard to explain and they're so complicated is the statute itself is tremendously complicated, over 1,000 pages. It was also enacted in a somewhat irregular way in the sense that because of the lack of votes in the Senate to overcome a veto, portions of the law were enacted through something called the reconciliation process, which limits the sorts of things that can be done. You can't just pass any piece of legislation. And the statute didn't go through what's called a conference, which is where the members of the House and Senate get together and kind of fine tune and dot every I and cross every T. That kind of editing process that most complex statutes go through, this statute didn't go through. And so as a result, there are a lot of rough edges. and it's on a very controversial issue. So you have a large, complex statute involving a very ambitious exercise of federal power that's highly controversial, that is a bit rough around the edges, and that really creates lots of opportunities for litigation. These are examples of where some of that litigation can arise. And I guess just to add to that, the way the Supreme Court resolved the individual mandate question, deciding that it was a permissible exercise of the tax power, is something that it's not clear was thought through what all the full implications of that might be. And so again, there's some questions we have to answer that normally we would not have to answer, or that aren't answered very often.
Great. Sai, do you agree that these challenges are technical because of the way the bill was passed, or do you have another take on the matter?
Well, I think that at least some of the challenges that you're referring to, Jeff, are not really technical. They're just unfamiliar, and they're unfamiliar because they're far-fetched. They're grasping at straws by people who are disappointed that the Affordable Care Act hasn't been blocked politically and was not blocked in the Supreme Court a year and a half ago on constitutional grounds. And so they have come up with, they've found parts of the Constitution that nobody's been paying much attention to and shouldn't pay much attention to, and which the courts won't pay much attention to. So I think that's why some of them seem kind of hard to get one's arms around.
All right, well, the audience can decide after we've actually parsed the various challenges and evaluated the arguments. Let's begin with the first one. The law says that only tax credits established by a state are eligible, and the claim here is that federally established exchanges should not be eligible for tax credits. Jonathan, explain that argument a little more fully and what the heart of that challenge is.
So the portions of the healthcare law adopt what is often referred to as cooperative federalism, which is an approach to implementing complex administrative system where both the federal government and state governments play a role. This is very common in the environmental context. The EPA works in conjunction with state agencies. The Senate bill, which became the PPACA, adopted a similar model where states were going to be encouraged to create exchanges in which people could buy health insurance subject to certain federal limitations and federal inducements. Typically, when you have a cooperative federalism approach, the federal government gives the state the ability to implement something, but then tries to give them an incentive. And the way the law is written, it says that states shall create exchanges, but the federal government can't force states to do that. It just has to hope that they do. And then when it says, provides for tax credits to assist people in purchasing insurance in the exchanges, it says that those tax credits, the way you calculate those tax credits in part is by looking at the purchase of health insurance in an exchange established by a state under Section 1311, and Section 1311 of the law is the part that instructs states to create exchanges. At the time this was drafted, the assumption was that every state would willingly create its own exchange because states would want to play the role of implementing the law rather than relying upon the federal government. That turned out to be a bad prediction, and about 30 states decided they didn't want to create their own exchanges. The IRS, in response to this, issued a regulation saying, even though the statute says that tax credits are available in exchanges established by a state under Section 1311, a federal exchange, which is neither established by a state nor established under Section 1311, can nonetheless provide the tax credits. There are 4 pending lawsuits challenging this, arguing that this authority to authorize tax credits was not given to the IRS. The IRS only has the authority to provide tax credits where expressly authorized by the statute. And one decision last week, a judge held in favor of the IRS in the District Court in District of Columbia. That case is already being appealed. And there are 3 other cases in Virginia, Indiana, and Oklahoma raising the same claim.
Great. Now, Sai, when we talked about this initially, I think both of you agreed that this was the challenge that had the greatest chance of succeeding. But as Jonathan says, a federal district judge has just rejected this claim that the federally created exchanges are not eligible for tax credits. Tell us on what grounds he rejected it, and I presume you think that was the right thing to do, and really what the stakes of this case are.
Well, I should make clear that when we say this case has the greatest chance of succeeding, it doesn't mean too much because the other cases have about zero chance of succeeding or even getting into court. And I think we both agree about that. So I should also just note that Jonathan deserves enormous credit for thinking up the legal theory behind this case. And it is really a exemplary effort, although not untypical on his part, of very creative legal thinking.
A constitutional mazel tov.
It's creative because he and his co-author spotted this thing in the statute that prompted them to come up with their theory many months after the act was passed, and no one in Congress had any such notion as they have come up with. And it is also creative in the sense that all of you out there probably think that the objective of the people who wrote the Affordable Care Act was to achieve near universal health insurance and increase the number of people who are covered by health insurance. Under this theory, that isn't exactly true. Actually, Jonathan is arguing, and his allies are arguing, that the people who wrote the Affordable Care Act actually intended to deny benefits to 80% of the people who would actually participate in these state exchanges if the states decided not to set up their own exchange or were unable to set one up fast enough or in compliance with the statute's requirements, and hence the federal government would do the exchange. And as Jonathan's co-author is prone to say, if successful, their legal theory, if upheld by the Supreme Court or other courts, their legal theory would drive a stake through the heart of the ACA, and that is correct. The problem is that while creative, the legal theory is not correct, and as Jeffrey has just said, a federal judge in the District of Columbia last Wednesday ruled that it is not correct. Very briefly, the issue is whether a couple of phrases in the statute which do indicate the interpretation that Jonathan is promoting, namely that tax credits and subsidies would only be available on exchanges which are run by the state. The judge said, yes, those phrases say that, but you don't interpret a big statute by simply taking a couple of phrases in isolation out of context. You have to look at the whole statute, and when you look at the whole Affordable Care Act, you see other provisions which confirm that its text is harmonized with its purpose. Its purpose was to spread health insurance, not to constrict it and not to keep it unaffordable to people who need it. So that basically is the nub of the issue, whether or not the statute or statutes generally should be construed with a kind of blinkered focus on one phrase and then imposing an interpretation of the whole statute by looking just at that one or two phrases, or whether you have to look at the whole statute.
So, Jonathan, first of all, congratulations on being the James Madison of this particular challenge to the Affordable Care Act. You know, before I want you obviously to respond to the Judge Friedman's opinion, but tell us more broadly, what's it like to come up with a legal theory like that? Are you sitting in a room and thinking, you know, how can I nail this thing, or
No.
or Isaac Newton, you know, like what is it?
It was-
how does it happen? Where were you?
It was an accident. I mean, I do a lot of work on federalism, a lot of work on cooperative federalism in particular, about how the federal government and state governments either cooperate or conflict when trying to achieve various policy goals. As a result of that work, I've been asked to give a paper at a healthcare law conference at Kansas on the way the healthcare law adopted either traditional approaches to cooperative federalism or did things new. So I did what you should do. I read the statute. And I noticed that there were various provisions in the statute, quite a few in fact. The most commonly noted are those relating to Medicaid, where the federal government was using various levers that it has to try and induce states to cooperate and play a role in implementing the statute. And at the time, just noticed that it was interesting that in addition to, for example, not providing for subsidies to individuals who earn less than 100% of the poverty level, right? So there is both a ceiling and a floor to your income if you want to be able to get subsidies, imposing conditions on receipt of Medicaid funds, which the statute clearly does. It also, as written, expressly limited the tax credits and subsidies to exchanges that were operated by states. And initially, this was just an interesting aspect of a law that, as I already noted, did not go through the normal editing process that laws normally do. It was also a somewhat controversial issue because the Senate bill had always adopted a model of trying to rely on states to create exchanges. The House bill, which was never enacted, or was passed by the House but never enacted, was going to rely upon a federal exchange and not on state exchanges. And so this was an issue that people disagreed upon. But the Senate approach, because of the election of Scott Brown, prevailed. At the time, I didn't realize that the way exchanges interact with the employer mandate, with the individual mandate penalty, and so on, that it would have that effect. At the time that I wrote the first paper on this, it wasn't even clear how many states were going to refuse to create their own exchanges. Most people writing on the subject at the time believed, in fact, the president also said this the day he signed the legislation, that every state would willingly create an exchange. And so it was initially a curiosity about how the law was written that didn't appear to have much relevance. Now, other people that including Michael Cannon of the Cato Institute, who I've co-authored a paper on this with, pointed out that the way the law is written, this ends up having domino-like effects in terms of other aspects. And because so many states have resisted implementing the law, it clearly has a big impact, just as the decision of many states not to accept the Medicaid expansion has a big impact on whether the law does what those who authored it intended it to do.
Cy, what's your broader thought about these textualist readings, which are really being invoked to disrupt an awful lot of practice? So in the Supreme Court arguments last week about recess appointments, Justice Elena Kagan said, you know, it's not as if we've had 200 years of recess appointments that occur in between congressional sessions, and it's not as if someone just woke up one morning and read the text and said that that was wrong. Is there something about these textualist arguments that are very disruptive and not conducive to pragmatic governance in your view?
Well, I think this does get into weeds, but it gets into weeds in a way which unfortunately makes it possible for courts, when they feel so inclined, to do a lot of violence to what the people and what Congress intended for laws to achieve below the radar, because it's just too hard to follow. And the reason that that's true, Jeff, is that seizing a couple of words in a large-scale statutory scheme, lifting them out of context, and then imposing an interpretation that may be plausible if you just look at those words in isolation, is a wonderful way of badly distorting or undermining what a law is supposed to actually do. And that is what I believe, with all respect, Jonathan's proposed interpretation of the Affordable Care Act will and is intended to do, but it's also done in many other cases. I don't know about the recess appointments situation. I have views on that, and I think that saying that the president has no way of defending himself and no way of ensuring that he has subordinates who can enable him to faithfully execute the laws by narrowly interpreting the recess appointments clause, as the D.C. Circuit did and as the Supreme Court is being urged to do. I think that's wrong also. It's not a sufficiently broad view. But I think the particular point about narrow statutory interpretations is a very, very significant one and a problem.
Just because we're here to debate the constitutional issues of the day, have you, do you have views on the recess appointment case and the applicability of textualism to it? And if you do, can you explain sort of simply to the audience what the stakes are and how you think the text points?
Well, sure. Let me make a comment first just about textualism in the context of statutes, which I think Cy and I disagree on, but I think there's a very important underlying constitutional principle, which is in our government, agencies have no inherent powers, whether you're talking about the IRS, Department of Health and Human Services, the EPA, and so on. These are not entities created by this Constitution. They're agencies created by Congress through legislation. And they only have those powers that Congress gives them by enacting laws that are then signed by the president or in the case of a veto, where the veto is overridden. And so the reason why I think it's very appropriate to look carefully at text and to think that clear text, a phrase like established by a state under Section 1311 means established by a state under Section 1311 is because the ultimate discipline we have on agencies is the delegation of authority to them in the first place. And so we only want the IRS or the HHS or EPA or whatever else to have that authority was actually given. And the only way we ensure that that limitation is there is by paying attention to the source of their authority, which is the text that Congress enacts. And in this case, I think that creates some problems for what the Obama administration wants to do with Health and Human Services. A few years ago, if we'd been having this session, I would be telling you how this was creating problems for things the Bush administration wanted to do under the Clean Air Act at the Environmental Protection Agency, where they wanted to do things which many people thought were very good policy, but were not provided for in the source of the EPA's authority to implement those rules. When it comes to the Constitution, I think it's a similar principle in the sense that the Constitution is how we, the people, delegated authority to our government. The nature of the document is such that it often speaks in kind of broader language. I think in something like the Recess Appointments Clause, the question there is not merely what does the text provide, but also the extent to which our historical practice should inform how we read it. So the clause provides that the president has the authority to make a recess appointment when there's a vacancy that arises during a recess of Congress. And the question that is whether or not that gives the president the authority in part to define what is a recess. What if the president and Congress disagree over what's a recess? These are the sorts of questions that arise. And there's a dispute because if you just narrowly parse the language of the clause, it looks like presidents have taken liberties or at least stretched that language for quite a few decades. And one of the things the Supreme Court has to decide in that case is the extent to which the text limits historical practice. My own view is I think the court can actually set aside most of those harder questions and simply just hold that what was done with the appointments to that issue in the case is neither consistent with historical practice or with the text, and can kind of set aside the broader questions. And that's actually what I would predict they'll do, because if you have over a century of presidents doing one thing without litigation, it's a big deal to suddenly try and question that. And so I don't think the court's going to be in any rush to do that.
Since I raised it, Cy, what is your response? What should courts do when faced with a clash between historical practice and text, and what do you think they should do in a recess appointments case?
Okay, can I just say that I actually agree with Jonathan that courts have to apply the text of statutes. I think our disagreement in the case of the tax credits case is only what is the relevant text. And I think that the judge in the District of Columbia thought that you have to look at the text of the whole statute and then determine what it means. With respect to the recess appointments issue, which again sounds kind of formidably technical, the question is whether President Obama was authorized to make what are called recess appointments. The Constitution, of course, provides that most high-level appointments have to be confirmed by the Senate after the president nominates, but it also provides that the president, during a recess of the Senate, can make a temporary appointment to fill a position so that the government can continue to operate. And as Jeff and Jonathan have said, since the very beginning of the Republic, presidents have interpreted this recess appointment authority rather liberally, and that practice has been solidified. And in this particular case, President Obama named three people, gave three recess appointments to the National Labor Relations Board, which at the time only had two members, and it has 5 slots, and that was not a quorum. Hence, the National Labor Relations Board could not do business at all. So the labor laws that it administered were largely completely shut down, and all the protections for workers and unions that it's supposed to be enforcing literally could not be enforced. And the Senate was refusing to consider any of his nominations over a considerable period of time, and it made it clear that they were not about to empower the NLRB to go about its business. That was exactly what the Republicans in the Senate wanted to do and what their business allies wanted done. So the president finally said that I'm going to make these recess appointments. He did it at a time, over an extended period of time, when the Senate was not meeting, was not doing any business, but it staged, every 3 days, it staged a so-called pro forma session in which one junior member of the Senate had to come in, say, we're open for business, now we're closed. And he was operating under instructions from the Senate not to do any business during this session. So the president decided that these sessions were shams, and they were being held only for one purpose, and that is to create the pretense that the Senate was in session and not in recess, to block his being able to make these recess appointments or other recess appointments. And I should add that the president had been encouraged to do just what he did by a very prominent Justice Department official in the George W. Bush administration, Stephen Bradbury, who's a very respected lawyer in the conservative camp. He had been encouraged because Bradbury said these things are shams, and they are draining the president and the executive branch of his ability to see that the laws are faithfully executed as the Constitution requires. And I might just add, Jeff, I think that this is a different thing from what we've seen in the past, because what's going on now with the obstructionist conservatives politically is not just opposing individual nominees whom they don't agree with ideologically or who they think have character flaws, which is the purpose of the confirmation process, and a legitimate one. They are simply refusing to allow nominations to proceed across the board in agencies and programs that they would like to see not function at all. And that is a level of threat to the executive's ability to function that we've never seen before, and which I would say there's much in the Federalist Papers that suggests that though they never anticipated anything quite like this, they believed that the president should have powers to defend his branch against encroachments from the legislature, and that's why I think the court should not intervene here.
Of course, I'll ask you to respond, Jonathan, but let's keep things on a constitutional rather than political plane. Sy has made a claim about what the framers intended in the oral arguments in the recess appointments case. Again, Justice Kagan said the framers intended one thing, preventing the horse and buggy limits of technology from Congress not being able to meet, and now this clause is being used for something else, namely to allow the president to get nominations through a recalcitrant Congress. What's your response constitutionally to Sy?
Well, I think it's important to keep in mind what the recess appointments clause was about, which was that in the late 18th century, it was difficult to get Congress back together or back in session. Recesses would last for extended periods of time. Traveling back from Georgia or from Massachusetts to the nation's capital was difficult, and it might be months between sessions. And there was a recognition that length of time could be a really undue length of time to leave the government without people in necessary positions. It was not about giving the president the ability to go around a Senate refusal to confirm somebody. And whether or not one thinks the Senate's refusal to confirm individuals is a good thing or a bad thing, I think Cy and I would both agree that it's a bad thing, that the Senate should try and expeditiously consider any appointment or nomination that is made by the president. The Recess Appointments Clause, as a constitutional matter, was to deal with the practical problems of what do you do when a Congress just isn't home, not with a Congress deciding it doesn't want to cooperate. The pro forma sessions was not a new innovation. It had been done during the Bush administration. That's one of the reasons why Steve Bradbury didn't like it, because it had been done to his boss. It did, though, conduct business. It did enact pass legislation that the president signed. So we have a constitutional opinion by the Justice Department that says these sessions were valid for purposes of enacting legislation that the president can put his signature on, but not valid for purposes of preventing there from being a recess. That's I think, a difficult position to maintain. The other thing constitutionally that's just interesting, Teddy Roosevelt faced a similar problem. And what he did was to say that when one Congress ends and the next Congress begins, there has to be a moment in time between those two sessions. Congress can pretend there isn't, but just kind of metaphysically, there must be a point at which the old session is over and the new session has begun. And so he just said, that is when my nominations are being made. And he made a bunch of recess appointments at that point in time. President Obama could have done that a couple days, it would have only been a couple days different in terms of when the nominations were made. And a lot of us who just watched the evolution of the case wondered why the Justice Department didn't do what a prior president had done, so they would at least be able to say, what we're doing is not different. We recognize the Senate's doing this pro forma session thing. Prior presidents haven't tried to get around that. But we know that one session ends and a new session begins. There has to be that moment. Teddy Roosevelt did it. Republican president of 100 years ago, I'll do it too. That would have been certainly, I think, a cleaner way for the executive branch to try and stand up to the Senate on this point, because they've been able to say, we're doing exactly what a prior president had done, and doing something that hadn't been challenged, and so has been assumed to have been permissible for 100 years.
Great. Well, if any audience has earned the right to ask questions, it's this hearty one, which is brave the snow. But I did want to just very briefly put on the table the arguments for and against the other two Affordable Care Act challenges, which I think both of you agree are less likely to proceed very far in the courts. Those two claims are, first, that the president's decision to delay implementation of aspects of the Affordable Care Act violates his constitutional duty to take care that the laws be faithfully executed. Pretty briefly, Jonathan, what's the best argument on behalf of that claim?
Well, I'll just say two things. First, these arguments are very complicated because, as I'm sure you all know, there are several provisions of the law that have been delayed or suspended or waived temporarily, and the legal authority for each one is actually somewhat different. But the underlying principle is that Congress delegates authority to the executive branch to implement the statute. Sometimes it does so in broad terms, in broad ways. Sometimes it does so in a very limited way. So, for example, many provisions of the healthcare law have deadlines. The employer mandate takes effect on a particular day. Insurance plans, to be lawful, must satisfy the minimum benefits requirements if they are issued after a certain day. The concern about some of the waivers and some of the delays that have been announced by the administration is that in some cases these involve provisions of the Act where Congress set very specific deadlines. So the employer mandate is supposed to take effect on a date certain, and the administration is waiving those deadlines. And in some of these cases, there is no provision of the law that would seem to give them authority. So in some cases, the waiver of the individual mandate penalty, the law has a provision that says, in a case of hardship, the Department of Health and Human Services can waive the penalty. We can debate about what hardship means, but there's clearly a provision of the law that the administration can point to and say, hey, Congress anticipated that things might not work right. They gave us the ability to do it a little bit differently. There are other provisions of the law, like the employer mandate, where Congress said, no, we want this in place by a certain date. And where the president has gone against that, the argument is that the president is not faithfully executing the law. The last real quick point is we may think, and I certainly think that in some of these cases the president is not fulfilling his obligation. It's not clear that anyone has standing to raise a court challenge to these actions. But there are often issues in constitutional law where we may think that one branch of the government is not fulfilling its constitutional duty. That's separate from saying there's going to be a lawsuit. And in some of these cases, it's not clear to me there will be a viable lawsuit.
Great. Cy, again, pretty briefly, your response to the claim that President Obama is violating his duty to take care that the law is faithfully executed by delaying implementation of parts of it.
He is not violating his duty. You'll be amazed to hear me say. And that's for a simple reason. He is not refusing to enforce the law, the Affordable Care Act, his most important accomplishment. He is phasing it in. And he is adjusting the timing of various provisions of it because it's necessary in order to ensure that there is a smooth landing, not only for the law, but for all the people who have to comply with it or have to provide health care under it or whatever. And such transitional adjustments of statutory deadlines in complex regulatory schemes like this are routine in the government. The Environmental Protection Agency does this sort of thing of necessity frequently, often to the consternation of some of my friends on the environmental left. There's nothing unusual about what the president has done. As a matter of fact, George W. Bush's Secretary of Health and Human Services, Michael Levitt, 3 days after the delay of the employer mandate was announced last July, he wrote in the Washington Post that the decision to delay the mandate was, quote, wise, unquote. And that was based on his own experience in phasing in the prescription drug benefit part of Medicare, which also had a bumpy introduction, but now is very successful and very well received. And I certainly benefited from it myself. So I think that's the basic point, Jeff, that this is less than a tempest in a teapot. It's just frankly, I don't want to say this about Jonathan, but many of the other people that are making a big fuss, a constitutional fuss about delaying parts of Obamacare, they're just gussying up political attacks in constitutional arguments which have no weight.
Just because it's not it's a charge that's made in good faith. What do you think is in the minds of those who are pressing those charges? Is it really just gussing up political attack and constitutional debate?
I think it depends. I mean, it would not shock any of us to know that in Washington D.C. arguments are often made on the basis of convenience, and we see, criticisms of Obama made by Republicans today that are very similar to criticisms Democrats made of President Bush, and I mean, so that happens. And I think in any of these cases, you have to step back and say, okay, some of the people making these arguments may be making them for opportunistic reasons, but we need to evaluate them differently. In the case of the various delays, I think this is very important. There have been a lot of delays. Legally, they are not all the same. So if anyone, I think, says, oh, well, this is all just, the administration just doing what it can, or this is all the administration flagrantly ignoring the law, well, it actually depends on each one. I mean, this is a complex statute, and the nature of the administration's authority and its ability to be transitional or not actually depends on the provision at issue. To take one example, the employer mandate delay, the reason for the delay is that the provisions providing for, or the regulations providing for the reporting by employers that are necessary to enforce that mandate hadn't been issued and hadn't been developed. So the administration is saying the reason we have to delay is because we didn't do something else the law told us to do. That, to me, that's not a good argument. And we see cases like that all the time. There was an EPA case just a few months ago involving application of the Clean Air Act to biofuels, where the DC Circuit made quick work of similar arguments made by the EPA. In the case of the individual mandate penalty, there is a hardship exemption. Some people are finding out that they can't keep the insurance they like, and it's going to be hard for them to find something they would like in a short window. Whether that should have been anticipated or not, it's certainly plausible that the Department of Health and Human Services could see that as hardship. And so even if I or someone else might disagree as a policy matter, legally it's a very different question than I think the employer mandate one. So I think unfortunately in the political debate, we don't parse these out, and those of us that like the technical complexities, we like that. But political debate isn't always very accommodating of those sorts of complexities.
All right, well, there is a third Obamacare challenge. It's that the employer mandate, which Chief Justice Roberts upheld last year as a tax, is invalid under the origination clause of the Constitution, which has all bills for raising revenue shall originate in the House. But we have gusts of snow falling outside, and I think the lights are being turned off at 1. So I want to open up the group to questions. If anyone wants to ask about this third challenge, they're welcome to do so. If you prefer to ask other questions, that would be fine too. Yes, sir.
On this transitional argument, I think I can accept the argument that any executive has to have some flexibility in implementing a complex situation. But am I correct in saying that there was an exemption to applying the law to congressional staffs? That's not transitional. It seems to me that is a change. What is the constitutional basis for that?
That's a very complex one, and it's one I think that there was a provision added to the law proposed by Senator Grassley, if I recall correctly, that was a bit of showmanship. It was a bit of, okay, if we really think this is good for the country, we should be willing to make sure that we members of Congress and our staff have the same thing done to our insurance that's done to everybody else's. After the bill was passed, some legislators and their staffs realized what the potential implications of this were or would be. And the Office of Personnel Management has come up with a creative interpretation of the relevant provisions to allow Congress to continue to provide contributions towards the purchase of insurance. The contributions are not provided by the statute. The plans that they will be enrolled in are still under the statute, so it's a bit murky. I mean, my own view there is that legally it's a close question. But I think there, one can argue that the administration, in good faith, is trying to be responsive to the demands of a very important constituency, Congress, and legislative staff. But there is, some question whether or not they were a little aggressive in their statutory interpretation. There is a suit filed by Senator Johnson of Wisconsin in his personal capacity, challenging this rule. It poses some very interesting justiciability questions. There's a question of whether or not, as a legislator, he actually has standing to challenge a regulation that he benefits from because it will make his insurance more affordable. He's being represented by Paul Clement, who argued the individual mandate case in the Supreme Court. I have some sympathies for the legal argument. I'm not quite sure how he's going to establish standing, which is necessary for a court to answer the underlying question.
You have to think that Paul Clement might have been a little disturbed by the results of the afternoon AFC championship game. I mean, eventually Tom Brady loses a big game.
Certainly possible.
Question regarding precedent, particularly the first issue. Have there been cases previous that will help us understand where this might go?
In terms of the tax credit case?
That was the first
Yeah.
one, yes.
Good question.
It's a very good question. They're all over the map. I mean, one thing to understand about the Supreme Court when it comes to textual interpretation of statutes is that there is disagreement on the Supreme Court, and there's disagreement on the lower courts about the precise method that should be used when interpreting a statute. So just to take the two justices that are kind of at the extremes on this point, Justice Scalia, very noted strict textualist, he thinks that most statutes, if you pay enough attention to them, are clear. You should not look at legislative history because members of Congress will say all sorts of things to their constituents and to the press. What matters is what they actually did. You really need to focus on the text. Justice Breyer at the other end thinks that the courts should include looking at legislative history and need to pay a lot of attention to how statutes are actually going to work in practice and the practical effects of different interpretations. The other justices kind of span the spectrum in between. Breyer and Scalia have each written books on this. So, I mean, they have very well-formed views, very contrasting views about statutory interpretation. Most of the other justices have points of view, but that aren't nearly as well developed on this particular question. And this creates a problem for lower courts because you can find opinions by the Supreme Court that say very clearly you focus on the text. You can find other opinions by the Supreme Court saying, well, legislative history is sometimes important. And so it makes it a difficult issue to predict. I think that actually all of the inconsistencies in the broader text as a whole actually supports a very narrow reading of the textual provisions in that case. For those that are interested, I co-authored an 80-page law review article making that case. But it is a sufficiently complex question of statutory interpretation that people of goodwill and good faith will disagree, particularly because they start the inquiry at different places. Right? Justice Breyer and Justice Scalia, just again to use those as the polar positions, start the inquiry from a very different place. And so they're going to come up with different answers because they don't think the nature of the question is the same.
Precedents on the first case, Cy?
Well, let me just say I thought that Jonathan made a very balanced presentation, but I would like to note and underscore, no, I do think that, actually. I would like to underscore, however, that Justice Scalia, who is the most committed, quote, textualist, unquote, on the court, is very clear in his theoretical writing, anyway, that when he talks about the text of a statute, he means the text of the whole statute. He's been very specific in stating that you can't take a single provision out of context and think that you have accurately read the text of the statute. So I don't think that in principle, again, there's any real disagreement here. In terms of how you would look at the precedents, Jeff, frankly, the question is, in my view, just how political are the justices going to be when they get this case? Is this going to be a Bush v. Gore moment? Is this going to be a moment when 5 Republican appointees decide that at the time it was thought that they were cutting off a recount that might have changed the course of the 2000 presidential election, even though in retrospect it probably would not have. But in any event, they made what I think everyone then and now thinks was they voted their political gut and not what the law was.
Everyone may be an overstatement, I say in my moderator role, but...
Okay, everyone may be an overstatement. I'll concede that. In any event, I honestly think, Jeff, that's the determinant. I think that Judge Friedman's decision in the district court is, if you apply the law of statutory interpretation, if you use common sense in trying to determine what interpretation will further what we all know or what everyone on all sides believed that Congress intended, these challenges will be rejected by the court.
Final question. And then out into the snow.
Good afternoon, gentlemen. What is the purpose of what is the purpose that the Affordable Care Act supposed to serve? And I wonder if the Affordable Care Act will save us, the consumer, from the money-making industry that is controlling the healthcare provider. Practically, the way I see it, as a consumer, the healthcare industry is actually trying to create dependence among the people. It's not serving its purpose by making us healthier and more intelligent. So my question again, what is the purpose of the Affordable Care Act, and does it serve its purpose?
Okay, let me try to answer first. Your second question about the healthcare industry and so forth is way above my pay grade. I really don't know how to answer that. What is the purpose of the Affordable Care Act? I think that the purpose is simple, and that it is to promote access to affordable health insurance. Its primary goal was to cover with health insurance 30 or more million Americans who currently are uninsured. And it does so through two basic mechanisms. One is by creating these exchanges or marketplaces that, through private industry competition, is supposed to make insurance more affordable and competitively priced, and also to provide subsidies for people who still wouldn't be able to afford it. And that was supposed to capture about 15 million people, as I recall. The other 15 or more million were to be put in reach of health care coverage by the expansion of Medicaid to cover many more people than it had before. And that's basically what the purpose was. Will it be successful? Well, some of us read the papers more or less avidly. It's very complicated. And I think the Medicaid expansion part seems to be being quite successful in terms of signing up more people. Of course, in those states where partisan opposition has refused to accept the Medicaid expansion, even though the federal government is paying all of it to begin with and close to all of it forever, it's not going to be nearly as successful, regrettably. With respect to the exchanges, there's been a lot of people have signed up despite the appalling screw up in the rollout of the way the exchanges worked. But I think the jury's out on whether it will be successful.
Wonderful. Jonathan, last word in just a few minutes or less if possible. What is the purpose of the act, and will it achieve its purpose?
Well, I think one thing we always have to remember about complex legislation is that there really never is one single overriding purpose that explains the entire statute. Statutes are the result of compromise in large legislative bodies. In a statute like this, every vote counted, as we know. And so to understand the act as a whole, you have to recognize that. There are provisions in the act that lower the cost of health insurance. There are provisions in the act that increase the cost of health insurance. There are provisions in the act that are designed to allow the federal government to exercise its authority. There are other provisions in the act that are designed to give a lot of authority and responsibility to states. There are provisions of the act which actually serve to limit access to health care. One I already mentioned was the limitation on subsidies for people below 100% of the poverty line, written into the law. The statute as a whole has a lot of interacting parts which push in different directions. And that's something we tend to see in most complex statutes. Congress almost never pursues a single goal with tunnel vision, ignoring everything else. And so that's why we can't just say, well, it's about affordable insurance, so everything that reduces coverage can't be part of the act, because there are many provisions in the act which neither make insurance more affordable nor expand coverage, because there were other things that Congress was trying to accommodate. Sometimes it was because Congress wanted to make sure there were enough votes. Sometimes it was because Congress wanted to make sure that a particular industry would not oppose it. We know, for example, that the health insurance industry was convinced not to aggressively oppose the act by the inclusion of the individual mandate, and that was one of the purposes that served. And same thing with the risk corridors for insurance companies and the reinsurance fund. So we have to recognize that the statute isn't just this, arrow in one direction. It's a very complicated mix of things that often are in tension with one another. And that requires actually paying attention to each provision. Is it going to work? I'm skeptical. I think the way it was enacted was not Congress at its best. The lack of a House-Senate conference, the lack of going through the legislation, the lack of really thinking about how you enact this kind of social reform without the buy-in and cooperation of the states is something that's going to make it very difficult. And I think it will be something that we're dealing with for some time to come.
Can I make three quick statements?
Really quick.
Before we get in the snow, really quick. One, the Medicare prescription drug benefit is an example of a complicated change in the healthcare system that took a while for the kinks to be shaken out, but they have been shaken out. So I think that's a significant practical precedent here. Secondly, the Affordable Care Act is basically what then Governor Romney enacted in Massachusetts. It works very well. It's very popular. That is a demonstration of, if there is a wide agreement politically on implementing something as complicated as this, it can work. And finally, I think that given all the violent opposition that it's had so far, the results in terms of signups seems pretty impressive.
Ladies and gentlemen, you've heard a civil and thoughtful debate on one of the most important constitutional issues of our day. This is the only place in the country that it could have happened to. You're the only people in the country who would have turned out here. I can't imagine you're not already members, but if you're not, please join. We have an incredible fall and winter programming coming up, including a debate, the first of our constitutional debates with Intelligence Squared, that will pit Alan Dershowitz against Noah Feldman of Harvard Law School on the question of whether the president has the constitutional power to target and kill American citizens abroad, and much, much more. From the bottom of my heart, thank you for inspiring me by coming to this event, and we now have horse and buggies that will escort you through the snow, past Independence Hall, and back to your homes. Thank you so much. Thanks to our panelists.
Thank you.
Beautifully done, gentlemen. Thank you. It really is an honor.